Hello. Hi. Welcome back. Hello. Hi. I'm going to put the comments up on the screen today. Hello, everyone. What is today? Tuesday, November 25th. Hello. It's already been a long day. Hi. Welcome back. I am Melly. Welcome to my channel. We are back early. We're going to be getting into Karen Reed, I think maybe like a week ago. Oh, wait, let me make sure my settings are good. A week ago or two or something, I know we read the court document regarding Karen Reed basically suing everyone and their mom, basically the House of Defendants, if you may. So we read that. Definitely check the Karen Reed playlist out if you missed that one. And today we basically are reading the document from the O'Keefe family, which is John's family, obviously against CF McCarthy's and Karen Reed. So it's not a very long document, so I don't know that we will be here for very long reading this, but I haven't read it. So I figured why not read it on lives. So please hit the like button, subscribe, turn on your notifications. We are going to be live pretty much all day. We have a Kenzie live later, a Kelsey live. We have a hidden true crime live, and then we have another live. So hopefully we can get through them all today, trying to stay caught up on everything that's going on. So let's get into this document. Really, it's 14 pages. It's not very long. I mean, we read thousands of page documents here. But I think it'll be fine. We'll just get through it and we'll be caught up. And let me know what you think about the Karen Reed case. I haven't covered it thoroughly here, but I know I have mentioned it a lot, and I have actually done some of the lives on the second trial. So Karen Reed case is very controversial. I feel like the justice for John O'Keefe has been lost throughout everything that's gone on with this. You guys know all the issues with the Karen Reed case, and there's a lot of drama with that right now. Lawyers, other journalists, etc. So I'm not going to get into detail with that because that's not what we're here for. I'm going to pull up the document. This is the document filed on November 12th, 2025. And shout out to all of you in the chat who are here early today. It feels a little off for me to be here this early. Well, I've done it before, but nonetheless, it's something kind of new. But let me see. Do I like this? Okay, yeah, fine. We can read it this way. Yeah, let's see. This is Paul O'Keefe. And like I said, CF McCarthy's and Karen Reed. I feel like this is going to be interesting. It says non-parties, Jennifer McCabe, Matthew McCabe, Nicole Albert, Brian Albert, and Brian Higgins, opposition to Karen Reed motion to add parties pursuant to Mass R page 21. It says non-parties and witnesses in the Commonwealth's prosecution of defendant Karen Reed, Jennifer McCabe, Matthew McCabe, Nicole Albert, Brian Albert, and Brian Higgins, having been served by defendant Karen Reed with her motion for leave to add parties, along with proposed cross-claim pending, hereby write to the court to oppose the motion. Defendant Reed's proposed cross-claims and related factual allegations against the McCabes, the Alberts, and Mr. Higgins are a vile work of fiction lacking any basis in evidence or law. Indeed, these outlandish allegations are part of defendant Reed's scheme to defame and wrongly malalign the Commonwealth witness to evade responsibility for her actions on the morning of January 9th, 2022, and for causing the death of Officer John O'Keefe, who will be referred to as Officer John O'Keefe. The Commonwealth witnesses vigorously dispute defendant Reed's allegation and will defend against these claims. The Commonwealth witnesses will include motions to dismiss, potential removal of these claims to federal court as well as counterclaims against defendant Karen Reed and third party Aiden, ooh, Turtle Boy, also known as Turtle Boy, for defamation and other torts that they have committed individually and in concert. Hmm, clearly, I missed that. I didn't know Aiden was brought up in this, Turtle Boy. The Commonwealth witnesses, however, should not be forced to litigate these false allegations and their own defamation claims in the pending lawsuit brought by the family of Officer O'Keefe against defendant Reed and two other defendants for their role in causing the death of Officer John O'Keefe on January 29th, 2022, quote unquote, the wrongful death action. Bringing defendants Reed proposed cross claims into this action, along with the Commonwealth's witnesses, defamation, and other tort claims, is procedurally improper at this stage and will substantially increase the claims parties' factual disputes and legal questions in the case without any evident economies of scale. Moreover, plaintiff's wrongful death action is currently past the motion to dismiss phase, with discovery having commenced. If defendant Reed is permitted to file these claims relating to her criminal prosecution in this case, the motion practice on her pleadings will likely take months. Then, if defendant Reed's proposed cross claims survive dismissal, the Commonwealth's witnesses will file their own counterclaims against defendant Reed and Turtle Boy in this action. Those counterclaims could again trigger months of motion practice. As such, the current discovery schedule could almost be over before the pleadings are closed on the defendant Reed's proposed expansion of this case. Accordingly, defendant Reed's motion should be denied and she should be directed to file her proposed pleading, if at all, in a separate action. In that separate action, depending on what claims survive dismissal, it may be appropriate for the parties to consolidate the cases pursuant to Rule 42 of the Mass Rules of Civil Procedure. At this time, however, it is too early to determine whether the judicial economy and efficiency could be served by consolidation in the future. Nevertheless, it is evident that there's no basis to warrant joinder at this time, and the present motion should be denied. This is kind of crazy. Factual and procedural background. As set forth in the plaintiff's complaint on the evening of January 28th, 2022, defendant Karen Reed consumed 9 alcoholic drinks during an approximately 3-hour period at 2 different restaurants prior to getting behind the wheel of her SUV with her boyfriend, Boston police officer John O'Keefe. This whole 9 alcohol drinks, it really bugs me because I feel like alcohol is different for everybody and how your body metabolizes it and how you digest it and all of the above is different for everybody, right? And so 9 sounds like a lot. Is it a lot? Yes. But I mean, throughout the night, a long night, I don't know. Like, I think there's differing opinions about that, you know? How do I feel about it? I don't know. I would need to like like I'm stuck on that because well, they're saying approximately 3-hour period, but I don't know. Like, did we actually have those 9 instances on video? Would have to go back to the trial to watch some of this. I forget some of the details because there's so much shit going on in the Karen Reed case and it's actually it was the John O'Keefe case, and now it's the Karen Reed case. But let's continue. At that time, defendant Reed was clearly intoxicated and unable to safely drive her vehicle. Nevertheless, after a night of drinking, defendant Reed drove Officer O'Keefe to Mr. and Mrs. Albert's home at 34 Fairview Road in Canton, Mass. After Officer O'Keefe got out of defendant Reed's vehicle in front of the home, defendant Reed hit him with her car while she was intoxicated as she left. Rather than stop, defendant Reed left Officer O'Keefe lying seriously injured on the ground in front of 34 Fairview Road. Officer O'Keefe tragically died from the injuries he suffered when the defendant Reed struck him with her car. After hitting Officer O'Keefe, defendant Reed then drove her vehicle to Officer O'Keefe's home. A few hours later, at approximately 4:30 a.m., defendant Reed was frantic and woke up Officer O'Keefe's then 14-year-old niece and talked about how Officer O'Keefe was not home and that Officer O'Keefe may be dead and that the defendant Reed may have hit Officer O'Keefe with her car. Defendant Reed arrived at 34 Fairview Road around 6 a.m. Defendant Reed immediately spotted Officer O'Keefe in the area where her car had struck him a few hours earlier. Defendant Reed was hysterical. At home, Defendant Reed repeatedly stated that she hit Officer O'Keefe. Defendant Reed never told anyone in January of 22 that she saw Officer O'Keefe enter the home at 34 Fairview. According to testimony at trial, shortly thereafter, Defendant Reed spoke to the police. Defendant Reed told the police that she did not see Officer O'Keefe enter the home at 34 Fairview Road. Similar to Defendant Reed, the police questioned each of the Commonwealth witnesses, and each told the police officer that O'Keefe had never entered the home. A few days later, Defendant Reed was arrested for causing the death of Officer O'Keefe when she hit him with her car as she was drunk driving. Defendant Reed was eventually indicted by a grand jury and charged with second-degree murder and manslaughter in the death of Officer O'Keefe. In the spring of 2023, Defendant Reed, while awaiting trial individually and in conjunction with third-party Turtle Boy, embarked on a strategy to defame the McCabe's, the Alberts, and Mr. Higgins by falsely accusing them of inter alia, murdering and or covering the murder of Officer O'Keefe. Defendant Reed did so to evade responsibility for causing the death of Officer O'Keefe by diverting attention from herself. As outlined in the police affidavit, Defendant Reed started to coordinate with Turtle Boy in April of 2023, initially using an intermediate to coordinate Turtle Boy's public communications. Defendant Reed and Turtle Boy also relied on the messaging app Signal to communicate and coordinate strategy. Oh, Defendant Reed's and Turtle Boy's unlawful campaign, individually and collectively, to defame the Commonwealth witnesses has caused them substantial injury. Oh my goodness. I feel like every time I read one of these documents, I'm like, oh my God, I'm shocked. But it's like, and we know what's going on in the whole Karen Reed world. I feel like we're all sucked in it. I definitely am. Don't know about you, but what the hell is going on here? In the spring of 2024, Defendant Reed stood trial at Norfolk County Superior Court. Defendant Reed did not testify on her behalf at the trial. That trial ended in mistrial due to a hung jury. In August of 2024, the plaintiffs filed the present wrongful death action against Defendant Reed and other defendants. The court stayed this wrongful death case pending Defendant Reed's trial. It's really crazy to me, that the O'Keefes want to go after Karen this bad. But I get it. They think she's the one who caused his death, but like with all the information we have about Massachusetts police, we're talking about another case today with them. I don't understand what the hell they're smoking over there. It's definitely not something I want to hit because like what the hell? I'm like, we're gonna be talking about Kelsey Fitzsimmons later today, but nonetheless, here I am jumping track. Do they not like see what's been going on like with the corruption and Proctor and okay, they can full hardly believe that Karen was responsible and they want to believe their friends, but like at some point it has become like ignorant and just stupid. It's like the facts are out there. And so I'm really trying to empathize with the O'Keefe family because they do deserve justice. And so does John. And I feel like it's been Officer John O'Keefe. I feel like it's been tainted with all the drama surrounding the case. So I don't know. I'm just really like, I'm in my feels about the Karen Reed case lately, if you can tell. And I apologize. I didn't say hi to you guys. Hi, Debbie. Hi, Cree. Hey, Kara. I saw Kiraha in here. Vanjie, you're fine. You're fine. Yvonne, it was a cover up. No, you haven't missed a lot. You're good. Yeah. ATS is like, I'm totally sucked in. I know. I know. Hey, girl. Yeah. Thanks for being here. I know it's wild. It's wild. It really is. Okay, let's continue. So it says in the spring of 2025, defendant Reed was retried. She again did not take the stand in her defense. The jury found that the government failed to meet its burden of proof on all counts except the charge of operating a vehicle under the influence. After the verdict, this wrongful death action resumed. In August of 2025, defendant Reed moved to dismiss the complaint. In early October 2025, this court denied her motion to dismiss as to all counts except one. Then on October 20th, 2025, defendant Reed answered the complaint. On October 28th, 2025, defendant Reed served this motion pursuant to Rule 21 governing misjoinder of parties and asked the court to allow her to file a 9-count proposed cross claim with a mix of state and federal causes of action against 10 new parties, including the Commonwealth witnesses. Like I said, if you haven't heard that document or gone through it, I did read it, so it's on the playlist. Um, the argument. Rule 21 is not the proper vehicle for defendant Reed to join the Commonwealth witnesses and assert the proposed cross claims. As an initial matter, the present motion is procedurally deficient as defendant Reed mistakenly brings her motion under Rule 21 of the Mass Rules of Civil Procedure, which is not relevant to her proposal to add new cross-claim defendants and cross-claims related to a criminal prosecution to this wrongful death action. Rule 21 governs misjoinder of parties and states, quote unquote, misjoinder of parties is not a ground for dismissing an action. On motion or on its own, the court may at any time, on just terms, add or drop a party. The court may also sever any claims against a party. Under this rule, the court has the discretion to overcome a technical problem of misjoinder by adding the correct party or severing claims against a party. Okay, let's see. They just name a bunch of cases, so I'm going to skip that part. Rule 21 is inapplicable here. Defendant Reed does not seek to cure deficiency in the current pleadings. Instead, she seeks to add entirely new parties and subject them to entirely new claims surrounding not the circumstance of Officer O'Keefe's death, but rather her own criminal investigation and prosecution. Uh-oh. Oh shit. Yeah. Hey Laura. Laura's like a profesh at this case. Karen Reed is free. It's time to free Turtle Boy. I'll put up the comments while we're reading this. Okay. Indeed, defendant Reed's citation to Kaiser Foundation Health Plan, including Pfizer, in her motion to highlight for misuse of Rule 21 okay, they're bringing up a bunch of cases. The court held that the regional subsidiaries of the Kaiser Foundation Health Plan could be added as plaintiffs pursuant to Rule 21 to the lawsuit after trial to avoid a standing challenge on damages. The court found that there was no prejudice to the defendant Pfizer by the Rule 21 joinder because Pfizer had the opportunity to fully litigate damages associated with subsidiaries throughout the discovery and at trial. What's happening in this case, then? Oh, because she cited, okay. If you don't know who Pfizer is, they're a pharmaceutical company, a drug company. In other words, in this case, concerned a technical correction of the parties, not claims, in a case in which the parties had effectively litigated as if the new parties were always part of the lawsuit. That is not so here. Defendant Reed's proposed new pleading brings in new parties and new claims that are not part of the pending wrongful death action. I'm not a lawyer, but I'm kind of understanding what's going on here. So they're basically saying that like she brought in parties in that lawsuit that are irrelevant to like what I guess the O'Keefes are trying to sue her for. And that Karen's just basically out for herself and to solve her own criminal case. I know a civil case. And then there's a lot behind that, I think. So don't come for me. While the wrongful death action and defendant Reed's new pleadings are broadly related to the tragic death of Officer O'Keefe, the wrongful death action directly addresses what happened to Officer O'Keefe the evening of January 29th, 2022, while defendant Reed's proposed claims and allegations relate to the events that occurred after the death of Officer O'Keefe during her multi-year prosecution. There it is. Instead, defendant Reed should have sought to amend her answer under Rule 15 and sought to join the new parties, including the Commonwealth witnesses, under Mass Rule 20, which governs permissive joinder. Defendant Reed failed to do, and that alone warrants denial of this motion. 2. Joinder will cause delay and prejudice without any efficiency or judicial economy. Even if this court were to treat defendant Reed's motion as being made under Rule 20, the motion would still be denied. Under Rule 20, this court has discretion to allow joinder of parties and counterclaims, but should only do so where it would, quote unquote, promote trial convenience, and not where it would result in, quote unquote, prejudice, expense, or delay. Here, the court should decline to exercise such discretion. Defendant Reed's proposal to join the Commonwealth witnesses and other third parties of this wrongful death action would not advance judicial economy at this stage, but rather would substantially increase the complexity of the pretrial proceedings and result in delay and prejudice to the Commonwealth witnesses and plaintiffs. There are several reasons for this court not to exercise its discretion to join the Commonwealth witnesses to the existing wrongful death action. Defendant Reed's proposed course of action will prejudice the Commonwealth's witnesses' discovery and jurisdiction rights and will substantially complicate and delay the pending of wrongful death action with new parties, claims, factual disputes, and legal issues without any genuine judicial efficiency gains. Okay, I have something to say. It might be like a little bit controversial, but okay, so Karen Reed was found not guilty in the eyes of the law, right? We get that. So who killed Officer John O'Keefe? Because that murderer is still walking around, right? Okay, we get that. So now they want to continuously sue her like civilly, but like for what exactly? Like they want money and they want justice, but I feel like is this like, is that really what it's gonna take for them to heal? And that's like a whole nother conversation, right? Is like, is that really what you need? You just need to take money from Karen Reed because at that point, in my opinion only, it means that, okay, well, they're past somewhat John's death and figuring out who truly did it. But they want to continue to come after Karen Reed, but taking money for her, I don't think solidifies or justifies the pain and the healing that they might never get because of Karen Reed being found not guilty and them being friends with the people who allegedly did it. Now, did they allegedly do it like it's been said and, whatever, whatever? I mean, no, but like if you follow this, I guess we all have our own opinions, but does that make sense? Like what the hell I'm trying to say? I'm like, am I just rambling about Karen Reed up here? I honestly don't understand her civil case too much, to be honest, so I'm interested. Well, she's suing everybody and their mom because, they set her up, basically. And then O'Keefe's that's where I'm coming in like, okay, but wait, the O'Keefe's want to sue for what? Like Karen, she wasn't found guilty, so now they want to sue her for like the pain and emotional distress, but it's like, okay, but it wasn't Karen, according to the law. And so I'm just like a little confused, I guess. Like, what do the O'Keefes get out of this? They want some kind of civil justice in the eyes of the media? Like, is that what it is? Because I feel like it's kind of coming to like a pride moment. I know people are probably gonna unsubscribe, but like for those who believe that, Karen Reed was guilty. Like what is the point of this? I guess just money. And then they want to come after CF McCarthy's because what? They served Karen Reed 9 drinks, et cetera, et cetera. Well, it is a bar. People do like to get drunk. Is that illegal? No. Is it illegal to drink 9 drinks? No. Did they test her metabolism or whatever alcohol content, liver, I don't know, liver test on how drunk she was that actual morning or time of the incident? No, it was after the fact. So I'm just like a little confused about why they're trying to sue Karen just for money. Yvonne says, I think they're trying to say it's her fault that he died. But I mean, They already proved in court it's not though, right? Like, she was found not guilty. We was I drunk? Like, we saw trial number 1 and trial number 2. Oh, I should probably take because you guys probably can't see the, so I don't know. I guess I just need to know, like, my heart does break for them. I don't wanna seem like I'm being an asshole, like, "Oh, I don't care about the O'Keefe's feelings," because I do. Yvonne Laura says, "Yes, Yvonne, you're right, like Ron Goldman's family against OJ." Yeah. Carrie says, "When I think about civil versus criminal cases, I think of OJ." I know we do all think of that. He was found innocent but guilty civilly. So he was found so sh okay, so Karen Reed's innocent allegedly to according to, her being not found guilty. ATS says, "Prop for money, but they just act like they really think she did it." Yeah, I have a lot of opinions on this. Not guilty criminally, but you can still be guilty civilly. Okay. Well, shit. Like, it just seems like, again, they're mentioning it in this document, like they want justice for John O'Keefe, right? Like, I do get that that's their family, but like, is that justice? I guess is what I'm trying to get that at the end of that little like talk moment. The Commonwealth witnesses will have substantial motions to dismiss if defendant Reed is allowed to file her proposed claims in this action. If defendant Reed is permitted to file the proposed cross claims against the Commonwealth witnesses in this wrongful death action, or if she files it in a separate action, those pleadings will be subject to substantial motion practice. Anticipated motions to dismiss include requests for dismissal based on the mass strategic litigation against public participation, okay, the anti-SLAPP statute, as well as on statute of limitation grounds. Such motions are likely to be successful or, at the very least, substantially narrow the scope of defendant Reed's proposed cross claims. Moreover, under the anti-SLAPP SLAPP statute, all discovery in this proceeding would be automatically stayed once the Commonwealth witnesses file that special motion to dismiss. While the court could resume discovery for some existing claims in the wrongful death action, there is a serious risk of multi-tiered discovery if defendant Reed's proposed cross claims are brought into this case at this time. These timing issues are compounded because the Commonwealth witnesses would have the right to an immediate appeal if the anti-SLAPP motion were denied. Oh. Given these significant legal deficiencies in Karen Reed's proposed claims, this motions practice could take the parties several months, if not longer, to brief and for the court to resolve these motions. Let me look this up. Um, Furthermore, if defendant, wait, did I just read that? Furthermore, if defendant Reed's proposed clock, yeah, were to survive dismissal, the witnesses would be compelled to fight the defamation. Were to survive dismissal, the Commonwealth witnesses would be compelled to file their defamation as counterclaims against defendant Reed and Turtle Boy in the present action. That could result in further motion practice. In the meantime, discovery in the present wrongful death action could be substantially complete. Indeed, the current discovery schedule ends in August of 2026, which may leave only a few months for discovery on defendant Reed's cross claims and the Commonwealth's defamation counterclaims. That truncated discovery would needlessly and substantially prejudice the Commonwealth witnesses, which alone also warrants the denial of this motion and a direction that defendant Reed pursue a separate action. Alternatively, discovery in the wrongful death action may be stayed pending these motions, which would also needlessly delay adjudication of this lawsuit. B. Defendant Reed's joinder strategy will prejudice the Commonwealth witnesses by likely foreclosing their right to move the litigation to federal court. Next, defendant Reed's proposed cross claims include several counts arising of the federal law. including count four for conspiracy to deprive Miss Reed of her Fourth Amendment rights against the McCabe's, the Alberts, and Mr. Higgins. Absurd as it is on the merits, if defendant Reed files this pleading in a separate action, the defendants would have the statutory right to remove defendant Reed's complaint to federal court. However, by adding these claims as proposed cross claims in the plaintiff's wrongful death action against the proposed counterclaim defendants, defendant Reed will likely foreclose Commonwealth witnesses' right to seek removal to federal court. In particular, the Supreme Court has held that the removal under whatever is not permitted for counterclaim defendants. Oh, since then the courts have expanded the Supreme Court's reasoning to include et cetera, which covers removal for federal question jurisdiction. Given defendant Reed's tenuous basis to seek leave to join claims relating to a criminal prosecution to this wrongful death action, the court should avoid inflicting undue and unfair prejudice upon the proposed new cross-claim defendants. By denying the motion and forcing defendant Reed to file this pleading as a new action, the court will ensure that the proposed counterclaim defendants' jurisdictional rights are not inappropriately foreclosed. If the motion is allowed, the Commonwealth witnesses will have to file defamation and other related counterclaims against defendant Reed and third-party Turtle Boy in this wrongful death action. Oh my goodness. There's a lot here. There's a lot. I saw someone says I wasn't yelling. Let me see. Laura says, I think the bars will just throw the family some money and they ought to take it. Bars have insurance for that sort of thing. And let's face it, she was hammered. Was she hammered? Prob for the money, but they'll just act like they think, oh yeah, I read that, I think. Oh, hey, young Black economist. The Turtle Boy cult is a bit out of control though, guys. Yes, they're constantly attacking everyone who doesn't agree with absolutely everything that Turtle Boy says. I have we're gonna have to discuss this on a later live when we do like the shit talking live. Not necessarily bad, but there's a lot going on, and I'm not gonna get involved, of course, because I'm not like, I'm into the Karen Reed case, but not like a lot of other people are. And I just feel like there is a lot going on over there in that community. I mean, if I was them, I would try to sue also. Why not? They can at least get money out of the insurance companies. Yes, we saw this in the Jamie Komorowski case. If you guys are not familiar with Jamie Komorowski, she's the one who was driving drunk AF and she hit the bride. Remember that case? They did like basically the exact same thing, going after like the bars and stuff. And I think we saw it in the Riley Strain case as well. Yeah, I mean, I don't know. I guess if that's gonna feel good for them and money, I guess. Who doesn't want money? Young Black economist says, I mean, they're even attacking Karen now because she doesn't want to be recorded by someone, which is a valid ask. True. And then there's laws behind all of that as well. Yeah, I know, Laura. Donate to TB, not Karen. He's facing 90 years in jail. She's being sued. Young Black economist says he's not facing 90 years, and also if his charges are for him going outside and screaming at people over and over, he didn't need to do that. She says, I'm not going to donate to either of them. It just doesn't make any sense for Turtle Boy fans to be constantly attacking people. Like, chill out. Okay. Young, he absolutely is facing 90 years in jail. That's a fact. Okay. You guys are teaching me a lot. If I steal something from someone and it's up to 10 years, I do it 9 times. That's on me. Yvonne says they said it was Karen's fault because she took John to the after party. Okay, but who invited him? Well, and it could be, like that's a different thing, who actually physically drove him there and brought him, but who set it all up? She left him there. He did go inside and got him. Yes. Yes, Yvonne. Thank you. He's facing up to 90 years. And okay, fair comment by ATS. And that whole shit with the whole like good time, bad time, this and that. I'm not a lawyer. But it seems like, so what, that's like the most he can get? That's like a life sentence or two, right? Like they were all hammered. True. True. They were all hammered. ATS says, but journalism isn't a crime. He didn't get charged for screaming outside. That's just not accurate. Laura says, I'm a proud member of the Turtle Boy cult. Black Cloudman says, I do understand. It's just his charges are from like going to school with the bullhorn. Yeah, at Jen McCabe. Oh, Jen Macabre. Um, it's absurd. Okay, let's continue. It says, I'll come back to the comments. We're like 3 pages away from finishing. Finally, defendant Reed's motion would not only expand the present wrongful death action with her proposed cross claims and the additional parties related to her criminal prosecution, but the Commonwealth witnesses would also be forced to file counterclaims against defendant Reed for defamation and other torts in this action. The Commonwealth witnesses would also have to join third party Turtle Boy to this action to assert similar counterclaims for Wait, did I just read that? Okay, Molly, I just like repeated the same sentence. Oh no, I didn't. To assert similar counterclaims for defamation-related torts. As explained above, defendant Reed and Turtle Boy, both in concert and separately, have defamed and substantially injured the Commonwealth witnesses through myriad false statements about them, for which the Commonwealth witnesses have planned to seek justice in a separate action. For you Turtle Boy people, did they release that? Because I don't think I have that document, and if not, I need to hit someone up for it. I have a friend who will give them. Mhm. Oh, okay, I see what you mean, HS. Oh, yeah, that whole mic thing's a whole 'nother thing. We're gonna talk about this on an after dark later tonight because, like, we need to I wanna get into not, like, get into the drama, but I need to, like this whole, like the civil stuff, I'm just kinda like, you know, I think because 'cause we've been following, like, Karen Reed and, like, John O'Keefe and those 2 trials. This is, like, a lot different, right? Civil and criminal law, but it's rather very interesting. While the Commonwealth witnesses contend their defamation claims and other torts against defendant Reed and Mr. Turtleboy should proceed in separate lawsuit if defendant Reed is permitted to bring her proposed claim in this action. The Commonwealth witnesses may be compelled similarly to bring their defamation claims in this lawsuit as well. These additional claims and parties related to unlawful conduct by defendant Reed and Turtleboy after the death of Officer O'Keefe would further complicate this wrongful death action by increasing the number of parties, claims, factual disputes, and legal questions. As a result, defendant Reed's motion would not create any judicial efficiencies at this stage by having this disparate legal claims based on different facts and time periods against differing parties in a single lawsuit. Rule 42 consolidation may be appropriate between the separate lawsuits at a later time. Defendant Reed provides no genuine justification for adding the proposed cross claims and the 10 new cross claim defendants to the pending wrongful death action. As stated earlier, defendant Reed's proposal will substantially expand the scope of the pending lawsuit, including dramatically increasing the number of claims, parties, issues of factual dispute, and legal questions for resolution. Okay, like, at this point, I'm literally having to write down, like, all these documents. Like, everybody suing each other is insane, and I'm in the middle of, like, basically going for my boss, but, like, at the same time, I just feel like there's a lot going on here, man. There's a lot going on here. It also risks unduly prejudicing the Commonwealth witnesses by truncating discovery on their claims and artificially foreclosing jurisdictional issues. However, it is possible that if defendant Reed pursues her proposed cross claims in separate action, as she should be required to do, the parties in the court may determine after motion practice is complete that there may be some efficiencies from consolidating discovery or the claims for trial under Mass 42. Until motion practice is complete, the parties will not know the potential for judicial economy from consolidation. At that time, the parties in the court will be able to assess the remaining claims and parties, including the defamation claims against defendant Reed and Turtleboy, and be better situated to determine whether consolidation is warranted. Conclusion. For the foregoing reasons, the Commonwealth witnesses respectfully request that the court deny defendant Reed's motion pursuant to Rule 21 to file the proposed cross claims in the pending wrongful death action. Respectfully submitted, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins on November 12th, 2025 by their attorney James L. Tuxbury and William S. Fish. Yeah, that's it. Wow. There's a lot going on here. I also agree that the bars will probably settle. Yeah, they will. I've seen them, I think, in almost all the cases that involved like Jamie Komorowski and a bunch of other ones. I feel like they've always settled. But I mean, okay, and this might be controversial too, but like, okay, so the bars are being sued and they're paying up. Okay, whatever, whatever. They take some accountability and responsibility, but like, is it their fault that that person likes to drink their ass off? Like, I know that's really not their fault either. Like, Karen Reed can pound those 9 drinks down. Well, is that everybody else's fault? Is that society's fault? Like how your brain was wired to drink alcohol? Like, I don't know. I feel like I can agree both sides and it is what it is. I'm just a little pebble in this case, but like, I think it's just very controversial all across the board. Everything. Young facts. They have major insurance for that type of thing. They do. As in civil lawsuit took 6 years. It was ridiculous. He would probably take long. Hers would probably take longer. That is crazy. 6 years? Yeah, pitting subs against each other is not cool. I agree. ATS 1000%. Thank you for saying that. Okay, so I was gonna read something else, but I think I'm not. Okay. I think that's I don't know if that's the latest one. There's so many documents for this case, like I can't keep track. I really cannot. Um, Regardless of the situation, crazy. Crazy, crazy, crazy. Yeah, and me and my kids finally settled. That's a long time. I mean, this was a long time ago too. I kind of feel like we're almost in 2026 and this happened January 2022. So, and then the Turtle Boy stuff, and then everybody's suing everybody, and then there's going to be individual claims, and then they're going to go after this and after that. I feel like it's never ending. Anyways, that was it for that document. I wanted to make sure I read it and you guys read it and heard it because I know I see a lot of you guys in all these other chats and channels and stuff in Turtle Boy. Um, Billy Wishton interview with Jackson. Is that on his channel? Laura? Let me pull it up. I've heard a lot of things. Does he care if we stream it, I wonder? I've heard a lot of things about this interview. I haven't watched it myself. The one from 2 months ago? Because that's the one that's coming up that I can see. Oh. No, it just said inside her civil case with Karen's lawyers. That one? Oh, yeah, I see Alan Jackson. Okay, maybe I wanna watch this. Yeah, most civil cases settle. Let me see if he puts anything about copyright in here. Do you guys know? I don't know who Billy Bush is. I feel bad. Does he strike people? Is he Lauren from Hidden True Crime? Um, I'm not sure how. Yeah. I mean, I feel like a lot of people have watched this, so I feel like it should be fine, but let's just watch a little bit of it. Yeah? You guys down? Okay, let's watch it. I mean, we might as well. We're here. Hey, Skylar girl, good to see you. He did scream at the witnesses. He's extra. I'm not sure how old you are, but journalists ago would knock on people's door. Oh, yeah, that's crazy. Okay, we'll watch a little bit of it. I'm down. I might have to watch all of this. I watched, it was interesting. But you watched it by yourself, ATS, or on your channel? I don't think I saw you go live about it. Did I miss it? Because I try to not to miss it, even if I can't hop into the comments. Um, Try to be there for your lives. Let's just watch a little bit of it. I won't play it in its entirety just because I don't want to be disrespectful. Should have hit him up before, but I didn't know about this. I mean, I had heard about it, but I didn't get into. Oh, Alan Jackson. I do like me some Alan Jackson, baby. Okay, let's see. Respectfully.
SUV. She was twice tried on murder charges by two different prosecutors. Her first, highly suspicious and tainted trial ended in a hung jury, while the second led to an acquittal on the murder charge in June. Karen was convicted only of operating a vehicle under the influence and received a year of probation. She was represented in both those trials by famous defense attorney Alan Jackson. The last time that Alan and I were together, I asked Alan, when is she going on offense? And he said, oh, it's coming. It's coming. Well, it's happening. And this time, Alan is on the team, advising. And of course, given all that he knows, he's a vital resource, but he's not in the lead position. That's Chaz Waters, who's going to join us in just a second. Alan is here. First of all, another amazing suit. The guy, you got to look the part. This is odd, Alan, because Karen's defending herself in a civil trial while also launching a civil suit the other direction, an affirmative suit. You guys made a pitch to the court to combine the two civil suits since they involve so many of the same witnesses. That would make sense. What are the chances of that happening?
Well, I'm going to leave it to Chaz to talk a little bit about that. The lawyer and the team that's leading this charge is Charles Waters and at Sheehan Finney and his team. They're phenomenal. Aaron and Damon and the folks that are behind this masterpiece that is the new complaint. Makes a lot of sense. I think you'll hear from him. It makes a lot of sense to combine certain aspects of the case or the cases. You'll hear him talk a little bit about what happened this morning. We just came from court. The reason for the suit is I just came from court. We're just sort of on the docket this morning, and Chaz is going to have a lot to talk about. It's very, very exciting, the idea that we are no longer just sort of receiving the slings and arrows, that we have gone on the offense. It's been a long time coming. Karen Read deserves that. She deserves to stake her claim about what actually happened and hold some folks accountable that need to be held accountable. A lot of folks that need to be held accountable, and accountability that's coming.
Yeah. Karen's suit makes accusations of gross misconduct for 3.5 years by the Massachusetts State Police and those working with them to cover up for the real killers of O'Keefe, who was found dead in a snowbank in January of 2022 outside the Alberts home in Canton, Massachusetts, with traumatic injuries to his head. So Karen's civil suit is filed in Bristol County Superior Court. The complaint names 8 defendants: former Massachusetts State Police investigator Michael Proctor, Sergeant Yuri Buchanan, Lieutenant Brian Tully, Brian and Nicole Albert, Jennifer and Matt McCabe, and the ATF agent Brian Higgy Baby Higgins. If Alan Jackson is the Micah Parsons of defense attorneys,
Higgy baby.
is Charles Waters. Chaz Waters is he's exactly that on the other side of the ball. He just left court moments ago. Alan, I guess you were there. You were all on Zoom for this thing?
We were, yeah. It was a remote hearing, and Chaz, as normal, did a phenomenal job. His team did a phenomenal job explaining to the court what the procedural posture and the contours of the case are. That was really the call of the day, a procedural update, a status case, or status update for the court in the case. And he's going to have a lot to say about what sort of takes place after this, what the next procedural posture of the case is. We're coming back the middle of December, and then from there on, the discovery process starts, and it's going to be very robust. I'll put it that way. But I'll let him say that. The thing that I'm most proud of is being associated with the complaint that was filed. It is an absolute, unequivocal masterwork of work product that Sheehan Finney and those folks put together and filed earlier this week, and it's been received with great aplomb, because it lays out a timeline, a storyline that is undeniable, and that's what we wanted. We wanted that story for Karen on her behalf to be laid out, and Chaz and his folks. There's nobody better So I look forward to listening in on the conversation that you have with him.
All right, well, have yourself a little sip of water over there. Settle in as you just whipped over here from court, and jump in at any time. We welcome Chaz Waters right now. He's in Boston. How you doing there, counselor? Good to see you, sir.
Billy, how are you?
I'm terrific. Thank you so much. First of all, before we jump into it, how did this case with Billy Bush, brought to you by LA Golf, and we continue on with Alan Jackson here in studio with me. Okay, we did Karen's in good hands with Chaz Waters. He's a cool guy.
He's a stud, right?
Yeah, he knows what he's talking
Yeah,
about.
he does. Yeah, he does. The whole team does. They're just phenomenal. They're beyond.
Well,
yeah.
and to your credit, you guys, you and Yannetti and your whole squad handed him you guys left so much gobsmacking, like, what? How did these people? It was so obvious to everyone who watched this trial that something happened in that house, and if they can go finish that off, that would be incredible.
Hopefully, yeah. I can't. Is it wrong for me to say I can't wait for these depots to start?
No,
I can't wait.
No, I can't wait either. I'm with you.
That'd be great.
So, on to your
We can't wait either.
latest case, if we can, the defense of Frazier Boehm. Frazier Boehm, how old is he now? Is he 23?
24.
24 years old.
Yeah.
Frazier's alleged to have killed 4 Pepperdine University students. The crash, which happened on the night of October 17, 2023, it killed these 4 students, these 4 girls, all in their 20s. He was speeding around an infamous stretch of the Pacific Coast Highway between Las Flores Canyon and Carbon Canyon, and it's called Dead Man's Curve in Malibu. He was 22 at the time, charged with 4 counts each of murder and vehicular manslaughter with gross negligence. What has changed, Alan? What has changed since the time of that fatal accident and now, right?
Have you guys gotten into that? I've been looking into it a little bit, and it's rather interesting, this other case that he's trying. Hey, First Liberties, what's the debate? Oh, there's a lot of things here for debate.
Is the district attorney who leveled the charges. Have you received any information that Nathan Hochman, the new DA, that he might feel differently about this case than the man who threw the book at Frazier Boehm, and that's George Gascon?
No, that's exactly the right way to tee this up. We start with
Yeah, and Tia says I haven't looked deeply into it. I looked a little bit into it. I might want to get into it because it sounds rather interesting.
the foundation. What are the charges? What are the appropriate charges? The DA's office thus far, through the deputy DA, who's the in-court voice of the district attorney of Nathan Hochman, has taken the position that the charges are fine. He's fought against the idea of removing the 4 murder charges, which we deeply believe, not just because it's an emotional issue, because it's a constitutional issue. It's a statutory issue. There is no foundation for 4 murder charges in this case. It is a tragic case. We all recognize that. We get that. But the job of the DA is to remove the emotion, to wring the emotion out of a charging decision and charge the right thing from a foundational perspective. 100%. We believe the law is extraordinarily clear that these are 4 manslaughter cases, charges at best. And I'll defend that all day long. I'll defend that all day long. What I cannot tolerate as a legal practitioner is overcharging for the sake of overcharging. I can't tolerate, the Constitution cannot tolerate, the community can't tolerate overcharging just for the sake of overcharging because it's emotional. And that's what happened.
And Gascon, the original DA, did that because
Correct.
he was seen as soft as hell on everybody.
At the time,
he
back
didn't
in-
prosecute anyone. So
Dude, this is crazy. I definitely need to look into it tonight. I think AJ's going to lose this one, but we'll see. From what I've read, possibly I can agree with that.
now he's like, I'm throwing the book at this guy, and this one gives me good cover because he's a young, handsome guy from Malibu. And sometimes when you say that, people go, oh, well, privilege,
Correct.
and he'll get off because he's got wealthy parents or something, and he's from Malibu, and he looks handsome and all that.
Yeah, in 2023, George Gascon was getting just hammered by his opponent, who happens to be the DA now, for being soft on crime. So this was a layup for him. Oh, yeah, like you said, rich, handsome young man from Malibu. I'm just going to throw the book at him. You want to see what soft on crime looks like? Hold my beer. right? That's the attitude I think that Gascon and the administration had back then to show, no, I'm not soft on crime. So they took it out on Fraser Bowman. Now he's carrying that water, and it's just unfair. And we just had a hearing in the last few days, a couple of weeks ago, a week and a half ago, in which we made the point to the judge, Judge Rubinson, who's a fine judge. He's a good jurist. Got no issues with Judge Rubinson, but I take great issue with his ruling because I think he was just wrong, and we're allowed to and
you filed the motion to
disagree.
dismiss the harshest charges, the murder.
Just the harshest charges, just the 4 murder charges. And I asked him, based on the law that we have in front of us, the law in California, the holding order from the magistrate at the preliminary hearing was legally infirm. It was incorrect. He never should have been held to answer on 4 murder charges. And that doesn't come from me. That comes from the Supreme Court. It comes from a Supreme Court justice who says speed alone is not enough. It's never going to be enough to rise to the level of implied malice.
Alan, no one thinks that Fraser Bohm, no jury's going to think that Fraser Bohm went out looking for 4 girls to hit with his car.
Of course not.
And use it as a weapon to take some lives. It's obvious.
Okay. We can kind of agree with what he's saying there. Like, no one's going to go out looking to take 4 lives, but in a car. But I mean, Leah Mumby did, and so did Mackenzie Shirilla. They used their vehicles as weapons. Now, what's the possibility of that? I don't know. I'm not a statistician. I don't really know. And I'm not a lawyer. I'm just a girl that likes to drink buzz balls. But nonetheless, you know what I mean? Like, good point. Yeah. Yeah, I need to look into this case. It's interesting.
That didn't happen. So it really is incumbent upon you and your team to show the circumstances of the night and what happened. And that, you're going to make the case that there was an incident of road rage, right? That Fraser was responding to. Someone was.
There it is. The road rage. The kid said somebody was chasing him and he was trying to get away. Oof. Yeah, according to LA County. Oh, a 22-year-old Malibu resident who's driving a BMW at a very high speed rate, reportedly as fast as 104 miles. Pretty close to Kenzie. Kenzie was like 99, 100 miles. I think it got to 100 miles. Let me play this for a little bit longer.
Out there antagonizing him on the road, and he was trying to get away? We
have made the argument in court based on the facts, not just some spin. It's based on the facts that we have in front of us, the same facts that the DA's office has in front of it. That Fraser Bohm, it was a confluence of issues that led to him, if he was speeding, to speed above the speed limit. Keep in mind, nearly every witness that was asked, how fast would you estimate Fraser Bohm to have been going at the time? They all said somewhere around 70 miles an hour. Not one person.
Gascon said 104.
So they've got an EDR data that they're electronic data recorder that they're relying on for that. We'll see. We haven't had an opportunity to download all the information. We haven't had an opportunity.
I definitely need to get into this because you guys know I love them vehicle cases. I've been on to Kenzie like no one's business. And then Leah Mumby, I did recently just cover hers as well. And her trial, actually, her court date just got moved. So that's why I wasn't able to get the hearing through FOIA. But yeah, she's back to court again in January.
Forensically look at it and test it. So we'll see how accurate that is, whether or not the wheels could have come up off the ground, whether or not the wheel spin without any friction could have just spun them up to a higher speed, indicating a false speed rather than an across the ground speed. So we'll see. We also know that Fraser was not drunk. He wasn't on any drugs. He wasn't distracted by any texting or emailing, anything of that nature. This was an issue that at the preliminary hearing, the prosecution said it's just speed. He was just going too fast. And because of that, we're going to justify, in our minds, we're going to try to justify legally 4 counts of murder. And the Supreme Court has spoken to that issue. And Billy, the Supreme Court, not me, not Alan Jackson, not our team, the Supreme Court has said that is inappropriate. That in and of itself is not enough to establish implied malice, which is what you need to get to a second-degree murder charge.
Right. How did when Judge Rubinson denied the motion to dismiss the most extreme charges?
I kind of agree with Young Box Economist says. Yeah, he's saying he's trying to get away from the guy who told him to slow down. It's just nonsense. It doesn't track, in my opinion. Yeah, I don't feel something here seems off. There's obviously there's always something else going on that we'll never know about. But he's saying he saw the kid at a light using his phone. We might have to do a live on this one later.
How did Frazier take this, and did you cushion this for him? Meaning, were you expecting the judge to do it, to dismiss it, or did you kind of know he won't, but we're going to do this because absolutely he should, and we'd like to set the precedent that this was asked for at the outset? Right.
So we had very high hopes. I had very high hopes because we had the law on our side. Sometimes you write motions and you're thinking, oh my goodness, we're having to sort of reach for a legal precedent. We're having to sort of stick a square peg into a round hole. Not in this case. It's a square peg, square hole. Absolutely fits perfectly. So I had very high hopes that we were going to win that 995 in terms of the first 4 counts. Just count 1, 2, 3, and 4 and get rid of those murder charges. And then let's get down to the business of litigating a criminal case like it should be. That didn't happen. How did Frazier take it? He took it like a grown man. He is a very intelligent young man who understands the character and quality of the case that he's facing right now. He understands the gravity of it, but he's also relying on his legal team and his family and his friends to support him as he goes through this. He knows what the gravity of this case is. His family knows what the gravity of this case is, and it is devastating. Can you imagine being 24 years old and being accused of something that legally you did not do and facing 4 consecutive life sentences in prison? Well, literally going to prison for the rest of his life. That is
24. I don't even think scientifically a male's brain is developed fully until 25, I thought.
That is a bridge too far.
Prison. He's in prison for the rest of his life. Mental prison,
no question.
Emotional prison for the rest of his life.
He's never, ever, ever going to get past this, nor does he seek to. He wants to make sure that what happens in the court of law is constitutional. And that's the reason I'm here, to make sure that the government gets it right. They cross their T's, they dot their I's. This is not a case of me trying to establish he's not the guy behind the wheel. That's not this case. This case is trying to define what actually happened that night, and we intend to do that. So we're taking Judge Rubinson's ruling and considering what our options are with that ruling, and we have an appeal option to that ruling as well. And we're very likely, as a matter of fact, we're sure to file that appeal.
In the court of public opinion, in the Karen Reed defense, you had the court of public opinion was just with you the whole way. You did a very good job of laying out the obvious nature of how sick these people are. You painted them exactly as the way you should, and everybody supported Karen. It's a little bit more challenging in this case because of what I said before. Here's the handsome guy, looks like he played football, big handsome dude from Malibu, and the parents are sort of probably less well off now, given everything that they have to pay for regarding this. But he's not an overly sympathetic character to the outside world. How do you communicate that? How do you mitigate that and say, please put this off the table? Is it one of those, with Karen, we imagined, right, this could happen to your sister, this could happen to you, that you could get railroaded by the police. This could be anyone's boy too.
Absolutely, that's true. Yes, obviously we are extremely mindful. Our entire team, the Baum family, the entire family is extremely mindful of the devastating loss that's been visited on 4 families. We get that. We understand that. But the job of the prosecution, the job of the government, when you intend to take someone's liberty, that's the one thing that we have that our
Okay, I have to say something because Laura says he has to do some time, but not his whole life. He obviously didn't do it on purpose. He was driving recklessly speeding. Okay. But what about Jamie Komorowski? What about Kenzie? I mean, they could say they were speeding too. It was an accident. not paying attention, driving recklessly. Therefore, they should all be let out then of jail. Kenzie should be on the TikTok showing her feet. Hey, Evie, good to see you, love. I mean, one person, two people, and then we have 4 people here. I don't know. It's complicated, I feel like.
Our founding fathers said is inalienable. It's an inalienable right that we have God-given right to liberty, to the pursuit of happiness, right? That's not just a tagline. That's not something you see on a bus bench. That is the Constitution under which we live every single day. So when the government decides, I'm not going to fine you, I'm not going to slap you on the wrist, I'm not going to take your driver license, I'm going to take your liberty, they have an obligation to do it exactly right. And in this case, there has been massive government overreach.
Wasn't it proven in court that Kenzie did it on purpose, though? Yes. But I feel like they have similar evidence, right? He said the black box proved it was 104. I have to get into these documents. Rather interesting case, though.
And that's the message that I want to get to the public is we're not suggesting that all charges be dismissed because of this overcharge. We're suggesting and demanding that the 4 counts of murder be dismissed so that we can properly defend the case that should be before us. And my hope is that there are enough folks out there that understand that Frazier nobody's ever going to suggest, including the prosecution.
And what does that look like fair? Okay, maybe not M1. It gets, downgraded and he gets murdered too, or manslaughter. I don't know. What for 4 lives? What does justice mean when it comes to how much time we think, allegedly, in our opinion only, that what's his name? Michael Bohm? I thought it was, oh no, Frazier Michael Bohm. That's what it is. What would be, I guess, justified morally, if you may. And legally, what would be fair? What would be Jamie Komorowski is 25 to life. Kenzie's 15 with the possibility of parole in 2037. Leah Mumby, I feel like, is kind of up there with Kenzie. We don't know yet. That's an ongoing case. Which other one have we covered involving a car? I feel like there's one I'm missing. Nonetheless, first and second degree isn't really about the amount of lies, but the intent of the defendant. Oh, okay. But I mean, 4 lives is 4 lives. That's a lot of lives, right? RIP. That's a lot. So the victims were Neam Rolston, Peyton Stewart, Asha Weir, and Deslin Williams. I apologize if those are not pronounced right. All 4 were slated to graduate in 2024. First degree is premeditated and second degree is not, right? Yes. I'm 32 and I was 25. It was 100 months. Oh yeah. Not anymore, black months. Good point, Skyla. I don't know. Yeah, RIP to the people who lost their lives. It's sad. Yeah, I know. I don't know. And then who am I to say what's fair? I'm not a lawyer. I'm not God. I'm not anyone. But 4 lives, that's Idaho 4. Well, that's a whole different case, but you know what I mean.
That Frazier, as you said in your opening comments, Billy, that Frazier intended to hurt anybody that night. He had picked up tacos that night. He was driving down PCH. Some other things happened which we are going to explore and we will make sure that a jury hears about.
Some other things happened
in terms of why he was trying to distance himself from other drivers or another driver in the circumstance. But our goal is to make sure that the public understands the government overreach is devastating to all of us. It's devastating to each one of us. It could, as you said, it could be
well, we're
your
seeing
kid,
it every
could
day.
be you.
That's in your favor. I mean, people who
It is. It is. I think the public understands that
Yeah.
you don't want. I don't care if you like a particular person or dislike a particular person. The question is, was there government overreach? There was in this case. And we're trying to shine a light on that and make sure that that doesn't happen. Because if it happens in this case, then it's a free-for-all. then every single time someone decides to get behind the wheel and maybe they're speeding, maybe they're going 5 miles over the speed limit, maybe 15 miles over the speed limit, miles an hour over the speed limit, maybe that turns into a murder case. Can you imagine a society in which every time you get behind the wheel, Billy, and you go over the posted speed limit, which you may not see, and people do it here in California, for Christ's sake, they do it all the time.
Me. Raising my hand. I'm being honest in the core of Mellyverse. Speeding tickets. I am a lot more than that, but I'm wholeheartedly guilty.
That every time you go over the posted speed limit, if God forbid something happens and there's a loss of life, now you're facing murder.
Yeah.
That's the overreach that has to be put back into
because
perspective.
your car, when it goes a certain amount over the speed limit, becomes a weapon. Is that what you and I drive the same car? And I got to tell you, I'll look down sometimes and be like, "Holy shit, that thing's going 89."
Absolutely.
That whole weapon thing is what I was talking about earlier in terms of Kenzie and all of that. I don't get speeding tickets, says for this. Oh well, aren't you a perfect little cat? Okay. Yeah, so Evie's like, isn't this, we already finished Karen Reed, but this was an interview about Karen Reed in this case that we're going to be covering. So I needed you to take notes, Evie, in class today, because we're going to be talking about it later. It says, dude, I don't drive at all as it is, and all this is making me never want to drive at all. Yeah, I'm not a big fan of driving either. Not necessarily the best either. So, probably better off just staying off the road. Okay, good. I'm here. Teach. Yeah, we're done. Class is done for this live now. You're going to be, I don't know, did I set it up for redirect? Anyways, if I didn't, we're going to hop over. Melly, play the Billy Bush interview. Laura, I want to do this on the After Dark later. I want to cover a couple different topics. So we're going to do like a little hangout. Calm down. I might not be drinking any BuzzBalls tonight. But I want to cover, so remind me, actually, I'll write it down. The Turtle Boy. I want to talk Turtle Boy later on the After Dark. Turtle Boy plus Billy Bush. I haven't seen that. So we definitely will. We have a Kenzie live. We have a Kelsey Fitzsimmons. We have a Hidden True Crime. I'll be sleeping. I'm freaking old. No, I'm going on earlier. It's earlier in the evening because now I'm here all day for streaming today. Hey, dropping into show support. Falsetto. Yes, my falsetto, babe. Thank you for being here. I appreciate you. What did you say? Oh, to Evie. Oh, yeah, I think I'm going to start Kenzie early. Woohoo, let me get my beer ready for tonight. Well, get your beer ready for right now, because we're going to hop over to Kenzie. Give me a little bit of time, and I will meet you guys there. Turn on all your notifications. That interview was Billy Bush and Alan Jackson, who's Karen Reed's lawyer. What other channel? Huh? Oh, you mean the second channel? The second channel and the Patreon will be up in the next day or so. So second channel, once I do, I will give it to my mods, and Nightbot will be dropping it. And then also with the Patreon, I've been working on some stuff for Patreon. I actually have some splendid ideas. We need to talk, okay? Family meeting tonight at the Melly After Dark. You said no BuzzBalls. Yeah, you know what? I think I need a break from them. They were too much sugar. I've been like drinking water like freaking like a plant. Really. Too much sugar. But anyways, nonetheless, I appreciate you guys and I love you guys. Turn on your notifications. Like I said, I will see you shortly. We're going to be hopping over to either Kenzie or Kelsey, but I'll see you guys on the next one. Shout out to my mods for being here, and shout out to all of you guys and the replay viewers. I will see you shortly on the next one.